Good morning. I'm going to go ahead and get you so you don't have to worry about it. All right, so Tuesday's lecture was sort of an introduction to tort law in general, and then we talked about intentional torts. A couple of points I want to make while we're still on that before we move on are that those are just a few of the torts that exist, the ones that we went over. That's not the full menu of torts that are available under Georgia law. Those are just ones that I wanted to highlight for you and ones that had some sort of application to the business context. But there are many, many more. The other thing I want to remind you about that is that everything that we talked about on Tuesday requires intent. That doesn't mean that if you did something by accident, if you caused harm by accident, that you're not responsible, you're not liable for it. You are, you're just not liable for an intentional tort. You're going to be liable under the tort of negligence, which is what we're going to get into most of today. But before we do that, pull up from your content the document that says intentional torts fact pattern. All right, pull that up, and that's less than a page of bullet points. So I want you to take 60 seconds to read through those, and then we're going to go back through them. All right, anybody still reading? A couple more seconds then. All right, so I'll set the stage for us. We got two convenience stores on opposite sides of the street. One is owned by Rusty, one is owned by Johnny. They hate each other. They have a long-standing beef, and they will stop at nothing to get back at each other. So the first bullet point is that one night last Christmas, Johnny sneaked onto the roof of Rusty's store and stole Rusty's Christmas decorations, and then he displayed them up on the roof of his own store. What tort that we have talked about, we're going to use the menu of torts that we talked about Tuesday. There may be some others that apply that we haven't talked about. Don't worry about those. Using the menu of torts we talked about Tuesday, who can identify a possible tort in the first bullet point? Jace, go ahead. Libel. Why would it be? I'm talking about the first bullet point, sneaking on the roof and taking the Christmas decorations.
Oh, trespass.
All right, trespass. What kind of trespass? Trespass to land or trespass to personal property? Both, because, all right, let's break that down. Why is it trespass to land?
He came to Rusty's store to take his decorations.
Right. Using the definition of trespass to land, he came on to a place that he did not have permission to go. We were assuming some things in that situation. We don't know what time of day he came over. If he came over during the business hours, that might not be trespass to land because he had the right to be on public, or not on, but the right to be on the property as a customer. When he went on the roof, though, that might be trespass to land because that's not a place where customers are normally invited to be. Right? So trespass to land, probably got that. You said trespass to personal property. Tell me about that. Why would that be?
Because the decorations belong to Rusty, not Johnny, right?
That's correct. And Johnny's actions in taking them did what? How does that meet the definition of trespass to personal property? by taking them, he deprived, I get them mixed up. He deprived Rusty of the use of his own personal property, right? Isn't that the definition of trespass to personal property? When you take something that's somebody else's and in a way that deprives them of the use and possession of their property. Good. I can think of another tort here. Conversion. What would be conversion? All right, so that's conversion. Why, Austin? Related to the definition. You're right. I just want you to use that's the purpose of this exercise today, is to use the definitions to determine whether or not we've got torts. That's right. He kept it and used it as his own. That's exactly right. That's when it went from just trespass to personal property to conversion. It's not one or the other. It's all those things. It was trespass to personal property when he took them. It was conversion when he kept them. That makes sense? If he went over there, Jace, and he just smashed them and tore them up but left them there, then do we have conversion? Probably not, right? He didn't keep them and use them as his own. But we still have trespass to personal property because he's destroyed them, and now Rusty can't use his own personal property. All right, good. Last week, Rusty rented a plane to fly over town with a banner that said Johnny's Go-Go sells hot dogs made from cats. Johnny's sales plummeted. Any torts there? Yes, Davis. Defamation, libel or slander? Slander spoken. Mm-hmm. So it'd be libel, right? All right, so the elements of defamation are we got to have a false statement of fact. So in order for Rusty to be liable for defamation, that has to be false, right? So we're going to assume that he's not serving cat dogs. The statement has to be about the plaintiff. Was it about Johnny? Yeah, that he operates a store and sells illegal food. Is that harmful to his reputation? Yeah. Did it get published to a third party? Yeah, when you fly something over town, people are going to see it. All right, and then did it cause damages? What would be the damages, Davis? Right, the lack of business. Johnny would have to tie the lack of business to Rusty's actions somehow. How would he do that, by the way? Let's say we're at trial and you are Johnny's lawyer. What evidence are you going to put in to show that you have damages? Yeah, you could, sales before this happened, sales after it happened. Maybe you have customers come in that testify that they would never eat a hot dog no matter what it's made from anymore because it freaks them out. I don't know. All right, good. There is another possible tort here as well, besides defamation. Wrongful interference. Tell me about that. Why would that be, Austin? So, right, the elements of wrongful interference would be taking actions that are harmful to another person's business that do not qualify as legitimate competition. You could make that argument. I like that. There's another one we could argue as well. Similar to defamation. Autumn. Fraudulent misrepresentation. So it's not fraud because fraud requires that I make a misrepresentation for the purposes of causing you to buy something from me. All right, so not fraud, but I like the way you're thinking. Rebecca. Disparagement of property. All right, why would it be that? What's your argument on that?
Incurred when it's publication of false information about another's product, alleging it is not what the seller claims.
All right, so do we have that here? Do we have a false statement of fact about a product? Assuming they're not doing it, right? And was it published? Yeah, it did get published, and they're assuming there are damages. You could make out a claim for disparagement of property. Remember, that was it's very similar to defamation It's just trash talking a thing or a product instead of a person. Defamation is specific to a person and their person reputation. Disparagement of property would be specific to the reputation of the product or the good. I think you can make out both there. That banner has alleged that Rusty does something illegal. Now, Johnny does something illegal, defamation, but also that his product is illegal, disparagement of property. So I think you could make out good arguments for 3 torts there. Johnny retaliates by printing Rusty's One Stop Sucks t-shirts. He gives them away to all his customers, and Rusty sues him for defamation. What would be Johnny's defense there? Does Johnny have a defense? You're Johnny's lawyer. What does Rusty have to prove for defamation? What's the first element of defamation? A false statement of fact. You're Johnny's lawyer. What are you arguing here as a defense? It's not a statement of fact. It's what, Autumn? It's an opinion. All right? Hard to prove. Not the same as saying you sell products made from cats or you're doing something illegal. This sucks as a subjective opinion. Defamation requires a false statement of fact. All right, so Rusty says that's it. He storms across the street. He's going to fight Johnny. They square off in the parking lot at Johnny's. Johnny swings at Rusty. He misses. He hits Ronnie instead. Then Johnny kicks Rusty in the head. And then Rusty bit Johnny's ear. I'm sorry. This is so hard to concentrate when they're banging like that. What torts do y'all want to allege here? All right, who said battery? All right, Davis, battery by who, on who, and why?
Johnny swings on Rusty first.
Okay, and missed. All right, that's assault. Why is that assault and not battery? Because he didn't actually make the contact. Say that again? Rusty bit Johnny's ear. That'd be battery. All right, so let's break it down for a second. Johnny swung at Rusty and missed. Any torts there? Assault, because why? The swinging, what? Created a fear of harmful or offensive contact in Rusty, in Johnny. I can't. I'm just doing nothing but confusing y'all. Johnny swung and missed. We are assuming something, though, there for that to be assault. What are we assuming?
That it was not self-defense.
Ooh, that it wasn't self-defense. Johnny could use self-defense there. We don't know what Rusty did. Rusty might have been running across the street with his AK-47 saying, Johnny, prepare to die. He might have the defense of self-defense. But what else are we assuming? If he swings at Rusty and misses, in order for that to be assault, Rusty has to be afraid of the swing. So we're assuming that Rusty saw it coming. Right? Remember? Otherwise, it can't be assault. If he never saw it, then he wasn't afraid of anything. On the swing, that is. Now, if Rusty's over there bringing the AK-47 and waving it around at people, that could be assault in and all of itself. You didn't touch me, you didn't swing at me, but you told me you were fixing to fire at me. Does that create a fear of offensive, harmful contact in you, Keyshawn? If I've got the gun, I'm waving it around and I'm telling you to prepare to die, that could be assault if I've made you afraid of offensive, harmful contact. All right. What about the fact that Johnny hit Ronnie by accident? He swung at Rusty and missed, but he hit Ronnie. We got a tort there? Negligence. We could have negligence. I could make that argument, but let's stick to intentional torts right now. Battery? What's the battery? Battery, why? Unexcused harmful and offensive contact. When he hit Ronnie, that was battery. Could it have been assault on Ronnie? How? Assuming what?
Assuming that Ronnie, whoever it was,
Rusty ducked.
yeah. Assuming that the bystander didn't see it coming, they won't be.
Assuming he did see it coming.
Assuming he did see it coming.
Then you've got assault. Right. Even though he didn't mean to. We talked, I think, on Tuesday a little bit about transferred intent, that if you're intending your action, but you hit the wrong person, you don't necessarily get off the hook for an intentional tort just because your swing connected with a different person than the one you intended. That's called transferred intent. Johnny kicked Rusty in the head. That could be assault and or battery, depending on if Rusty saw it coming. Rusty bit Johnny's ear, same thing, assault and or battery, depending on if he saw it coming. All right, Johnny posted an unflattering picture of Rusty with the caption, "Beware of idiots." And Rusty sues Johnny for false light, portraying him in a false light. If he sues him also for defamation, you are Johnny's lawyer. Rusty has sued you for that "Beware of Idiots" poster, alleging defamation and false light. Let's do defamation first. What's Johnny's defense? Right, good, Autumn. It's not a statement of fact. Defamation requires a false statement of fact. This just says "Beware of idiots." Okay? Keep going. What else would we say that is? Well, it's not a false statement of fact in that it's an opinion and that it doesn't directly call Rusty an idiot, just implies he is. But calling somebody an idiot is not defamatory, not a false statement of fact, it's more of an opinion. False light, though, is when you portray someone in a false light, you infer something about them. What's Johnny's defense on false light? It's along the same lines as the defense of defamation. The light that I portrayed him in was that he's an idiot, which is also an opinion and a subjective thing. Contrast that with what Rusty turned around and did, which is he posted a picture of Johnny in his store right next to a sign that says "Beware of convicted felons." How is that different if we're looking at it under a possible false light claim, Garrett?
That is a fact.
That is a statement of fact. But we're also assuming what? In order for Rusty to be liable, we're assuming that he's not one. Right? If Johnny is a convicted felon, then Rusty's defense is truth. Remember, truth is always a defense. That is a statement of fact, but it's not a false statement of fact. Good. And that is different than saying "Beware of idiots." Johnny knows that Rusty and Beth have an employment contract, but he offered to double Beth's salary to quit and come work for him. Any tort there? What tort could that be? Wrongful interference with contractual relationship. That requires there to be an actual contract that the other person knew about and that they induced one of the parties to break on purpose. We probably got that here. Assuming that Johnny knew that she was under contract with Rusty. All right, finally, Johnny hacked into Rusty's online dating account. He copied some pictures of Rusty and Ronnie's wife. He posted them on social media. Ronnie's wife was so traumatized that she developed PTSD and her hair fell out. So let's break that down. I can think of at least 3 torts in here. With respect to Rusty, whose account was hacked, what tort could Rusty sue Johnny for? Invasion of privacy, and specifically which invasion of privacy? We broke that down into 4 subcategories. But invasion of privacy is correct. I think it's the first one, intrusion into private affairs or seclusion. You got a right to expect that your online account that you have password protected is private, and somebody hacking into it would be a violation of that. Good. What about for Ronnie's wife? What could she sue Johnny for, Garrett?
Could be wrong, but what about the one that's like emotional distress?
You're exactly right. Intentional infliction of emotional distress. And what about this would qualify as that?
Whenever develop PTSD.
Yep, PTSD would be the evidence. That would be the good evidence at court of her emotional distress. But that tort requires there to be some egregious, objectionable, outrageous conduct. Is posting private pictures of people's sex lives outrageous and egregious behavior? I would say, if it were me, I would say yes. So I think you can make out a claim for intentional infliction of emotional distress. The pictures themselves got posted. That could be a tort right there. Look under invasion of privacy. Which one of those would you choose to charge Johnny with if you're if you're Ronnie's wife? Say that again? Appropriation now is when you use somebody's image for commercial gain. So that's close. Public disclosure of private facts. Good. Excellent. All right. So the purpose of that exercise is to show you how we might assess certain fact patterns, how intentional torts might fit them, how we might make the argument on both sides, and how there might be defenses to some of these things. Great job. Pull up your lecture outline now for negligence. I think it's part 2. So we're going to completely switch gears in terms of intent. Tuesday and our discussion up until now is all required intent. The rest of today is about the tort of negligence. Negligence is in and of itself a tort. We talked on Tuesday about all those different intentional torts. Today is just negligence, the tort of negligence. Negligence is defined when someone's careless conduct creates a foreseeable risk of harm for others. If I'm boiling that down to its basic essence, negligence means carelessness. Negligence happens when we do not exercise the degree of care that a reasonable person would be expected to exercise under the circumstances. You may not know it, but everything you did since you got up this morning and came to class involved a duty of care on your part. When you drove your car, Maria, what duties did you have to be careful in driving to school today? Stay awake. Good. What else? Not driving drunk. Very good. No, I'm not getting into that anymore. I'm just kidding. What else? Follow the law. Is that an expectation? So our duty of care in operating a motor vehicle is to do it safely, to pay attention, to not take risks that might hurt others, to go the speed limit, to stop at stop signs, to not be under the influence of anything. That's how we would define the duty of care in driving. What about walking down the hall on the way to class? What's your duty of care there? Keyshawn, what was your duty of care? Did you realize you had a duty of care walking down the hall this morning? What is it? What do we expect? What's the level of care we expect you to exercise when walking down the hall?
Talking out loud, just like screaming or something.
Okay, not screaming. We do expect people not to scream. What about paying attention to where you're walking? What about not running or swinging your water bottle or your backpack around? We all have the duty of care to walk down the hall in a careful way, right? Everything you do up until now and from when you leave here for the rest of the day, I want you to think about what your duty of care is in everything that you're doing. Duty of care is measured by the reasonable person standard. It's context and circumstance specific. We ask the question, what is my duty of care? My duty of care is the degree of care that a reasonable person would use under the circumstances. Context specific, circumstance specific. There are 4 elements of negligence that we're going to use to assess any possible negligence claims. So I'm going to give you those 4 elements, and then we're going to go deeper into each one of them from now to the end of class. The first is that there has to be a duty of care. I can't be liable for negligence if I didn't have a duty to be careful in the first place. If I'm walking down the hallway and Keyshawn is walking the other way and he trips and falls, I didn't have a duty to keep him from tripping and falling. I'm not negligent. I didn't do anything careless. So there has to be a duty of care. There has to be a breach of that duty, meaning that the person was careless. I've got a duty to be careful, and I wasn't careful. Those are the first 2 elements. The third is causation. My carelessness caused somebody else's injury or loss or damages. And then the 4th element has to be that there are actual damages. It would be careless of me to throw my laptop. Well, let's put that a different way. I take my laptop and I throw it like a frisbee at Keyshawn. He ducks and my laptop hits the board behind him, but doesn't cause any harm to him. Do I have a duty of care to be careful in the way I conduct my class? Do I have a duty not to, you shut that door, please, Garrett. Do I have a duty not to throw things at people that might harm them? I do. Did I breach that duty when I threw my laptop like a frisbee at Keyshawn? Yes, I was careless. Ooh, he doesn't have, so the negligence claim might fall apart at causation and damages. If he doesn't get hurt or nothing happens to him, then he doesn't have a negligence claim against me. Yes, I was careless, or yes, I had a duty to be careful. Yes, I was careless, but he didn't actually suffer any harm from it. Remember, tort law is about compensating victims for losses that they've incurred, not to punish them. Was it wrong of me to throw the thing at Keyshawn? Yeah. But if we're looking to punish Professor Tebow, then that would be a criminal law type thing, not a tort law type thing. Tort law is to compensate the injured party. If Keyshawn has not suffered any loss or damages, then he is not going to be able to sue me for negligence, even though I was careless, even though I violated my duty, because he actually has to have something to be compensated for. All right, the duty of care. Talked about the reasonable person standard. What would an objective, reasonable person do under similar circumstances? A reasonable driver would be expected to stop at the red light. Running it would be a breach of that duty. If I run the red light and run into Miss Davis's car, then that was a foreseeable consequence of my carelessness. Running a red light could result in me harming her property or person or others. There are special duties for landowners who invite people onto their property. And by that, let's think about the convenience stores again. Landowners and businesses have a duty to warn people that come on their property of dangers. That's why you go in the grocery store, you see the sign that says wet floor because they've mopped up a spill. They have a duty to warn you if the floor is slick and that you could be injured from that. Landowners have a duty to warn people of open and obvious dangers. And that may sound um, that may sound a little bit different to us, because if I walk into a place and I see if I walk into a mining site and I see that there's a giant pit, I should know better than to walk up too close to the pit where I might fall in or slip or dirt would crumble under my feet, right? But landowners still have a duty to warn everybody, because, yeah, I might recognize something as an open and obvious danger that other people might not recognize as an open and obvious danger. Maybe it's a child who can't read. Maybe it's a child who comes on the property and has never seen a mining operation before. Maybe it's somebody from another country who doesn't speak English, and so therefore the warning signs wouldn't mean anything. That's why we say that the duty to warn, the duty of care, is always going to be context specific. The other thing that I would stress to you in any negligence case is that we don't go around in our everyday lives thinking, I don't think, okay, I got to walk to my car after class, then I've got to drive downtown. What are all the things I need to do to be careful? We don't think like that. Negligence is always viewed from the courtroom backwards. Somebody got sued for not being careful, and we're looking backwards to see what was the duty of care that the person should have exercised under those circumstances. I can't foresee this, whatever circumstances are going to happen from me riding down Macon Highway down Winton Road into downtown. I don't know what all may happen. But if I'm careless on the way and I cause some injury and I get sued, then in the courtroom, we're going to look backward and say, first of all, what was Tebow's duty of care? Did he breach it? Maybe I'll give you an example on that. The speed limit on Macon Road is, let's say it's 45 miles an hour. Am I breaching the duty of care if I drive the speed limit down Macon Road? Probably not. Can you change the facts to where I would be breaching my duty of care by driving 45 miles down Macon Road? If the speed limit was 30. What about if there was a blinding snowstorm and I couldn't see more than a foot in front of me? I shouldn't be driving 45 when there's zero visibility, right? So it's circumstance specific. I can't say ahead of time it's negligent to drive 45 miles an hour, but I can say from the courtroom looking backwards, it was negligent for you to drive 45 miles an hour when you couldn't see. It was negligent for you to drive 30 miles an hour when your car was fogged up and you didn't use the defrost. It was negligent of you to drive 10 miles an hour down Macon Road while there was a parade going on, right? So we're always looking backwards whenever somebody has been charged with negligence. What was the duty of care that they should have exercised or anticipated? What was foreseeable at that time, looking in hindsight? Professionals are held to a higher standard of care than non-professionals. So if you go to the accounting firm and you hire them to do your taxes versus you asking me to do your taxes as a favor, and I'm not trained at all in tax prep or any kind of accounting, the duty of care that is expected from the tax professional is higher than the duty of care that you can expect from me. If I make a mistake preparing your taxes and you sue me for negligence, when we're in the courtroom looking backward, that's going to look a lot different on what you expect out of me than what you expect out of the professional. I know, I mean, it is right there, isn't it? Like, is the thing moving?
Yeah.
It is moving. They're like pulling it's like they're pulling the paper off of the thing. And they're speaking Spanish. All right, so back to the duty of professionals. It would be higher in their field than it would be for a lay person or a non-professional. Here's how a medical malpractice case works. This is a good example. All medical malpractice cases are negligence. At their heart and of their essence, they are negligence lawsuits. In other words, doctor, you didn't use the correct standard of care in operating on me, or in prescribing me this medicine, or in whatever treatment you gave me, you were careless. So if I have a procedure for to repair my broken leg, my right leg is broken, I go to the ER and the doctor operates on my. Anybody speak Spanish? You do? Hey! Can you stop that?
No. We're just blocking on top.
No, we're having class.
Oh, okay.
I cannot. You're going to have to stop for 45 minutes. Wait. Is that what he said? And that was English. I'm just making sure you didn't say something I missed. Okay. Back to the medical malpractice lawsuit. I go in for surgery on my right leg. The doctor operates on my left leg. I bring a negligence lawsuit for medical malpractice. I would say you had a duty of care to operate on the correct part of my body. You breached that duty when you operated on the wrong part. Your carelessness caused the injury to my left leg, and I have damages on that. What would happen at court is I would get an expert witness, a doctor, a professor, somebody who's an expert in that area, and I would have that person testify what is the correct standard of care in the operating room. Well, the correct standard, they would say something like, the correct standard of care is that before you do any operation, you verify that you've got the right limb, you verify with the nurse, whoever else is assisting, that you're on the right one. And that's the way it goes in the ER. You're not supposed to operate without verifying what it is you're doing. I would then say, okay, Mr. Expert, what did you review the facts of this case? Yes, I did review the facts of this case. It appears that the doctor did not verify which leg he was supposed to be operating on. This is a pretty obvious example because he operated on the wrong leg. But let's say that maybe a doctor didn't sew somebody up correctly. The expert would be testifying as to what we expect how we expect the doctor to sew somebody up. What's the right way to do it? And did this doctor do it right? That's what I'm trying to say. The doctor would have their own witness that would come and say, this is the standard of care, and I've reviewed what the doctor did, and the doctor did what he was supposed to do. Just because something went wrong, just because there was an infection, just because the stitch didn't end up right, those happen. Doctors can be as careful as they can, as they want to be, as they could possibly be, and there still could be a bad outcome. Bad outcome by itself doesn't necessarily equal negligence. That's what I would argue if I was that other person's lawyer. Okay? That's how a negligence lawsuit works. The jury or the judge is going to have to decide what was the standard of care, was it breached? The standard of care, when I told you at the beginning that it's context specific, let's think about a situation where I go in for some specialty eye surgery that only 3 doctors in the country are trained to do. I go to this hospital in Boston where this doctor does this type of thing, okay, and my surgery goes bad. Something goes wrong with my eye. The duty of care of that doctor the specialist in what he was doing is going to be higher than if I end up at the ER in Columbus and there's a general ER doc there who I've got something wrong with my eye and he's giving me emergency treatment for it. He's not trained in this other specialty. All right, his duty of care is different than the specialist's duty of care. If I live in New York City and there's a fire in my apartment and I call 911 and it takes them an hour to get there, then I might could sue the city for negligence. They have a duty to dispatch first responders in a timely way under the circumstances. But if I live out in a rural part of the county on an unmarked dirt road and it's the middle of the night and it takes the fire department an hour to get there because we have a volunteer fire department and they've got to round everybody up, then they got everybody there, then they're going out to a part of the county they've never been to before where there's no signs, they don't know where my house is. The duty of care, it might take them an hour to find me. That might not be negligent in the same way that it would be negligent for the fire department who's got a fire truck that I can see from my apartment building in New York City. Shouldn't take them an hour to get to me. That might be negligence in a way that the hour in the country isn't. So it's context specific. Causation. The carelessness, the negligence has to be the cause of the injury. All right, I can break this down for you in a couple ways. One is actual cause. Was my action the actual cause of the injury? Meaning, if it wasn't for my action, the consequence wouldn't have happened. Here's an example of that. I run the red light. I slam into a telephone pole, a power pole, and I hit it so hard that it breaks the wires. They fall down, sparking. They set off a fire in the dry grass below. That fire ends up, the fire department comes to put that out. And on the way to the fire department runs over somebody's dog. Okay? Am I the cause of that dog dying? I mean, I am, because if it wasn't for me hitting the pole, I'm running the red light and hitting the pole, the wire wouldn't have fallen and started a fire, which wouldn't have caused the fire department to come, which would have mean they didn't run over the dog. Now, if you're thinking that maybe the fire department has some negligence or liability there themselves, they may. But I'm the actual cause of it. Does that mean that the dog owner should be allowed to sue me for negligence and recover for the value of their dog's life? Let's do it a different way. If I run the red light and I hit Austin's car, is my running the red light the actual cause of his damage? Yeah. Should he be able to sue me to recover from me for the damage to his car? Yeah. Why is that? It was foreseeable that running a red light might end up running into another motorist. What about the power company? I ran a red light and hit their pole, destroyed it. Can they sue me for negligence to recover the value of their pole? Was it foreseeable? Was my running the red light the actual cause of the damage to the pole? Yeah. If I hadn't run the red light, I wouldn't hit the pole. It would have been broken. Should I be liable for that? Was it foreseeable that running a red light might result in me hitting a power pole and damaging the pole? Okay. What about the fact that the wires fell and started a fire? Could the owner of that property sue me for negligence for the damage that the fire caused? My actions were the actual cause, but for that, the fire wouldn't have happened. Should I be responsible? Was it foreseeable? Is that a foreseeable risk of running the red light? It's getting a little harder, I mean, it's not as clear as me running the red light and rear-ending Austin or running into the pole. We're getting a little bit farther away down the line. What about the owner of the dog? I'm the actual cause of that dog dying. If I hadn't run the red light, none of that would have happened. Should I be liable for that dog? It's not as clear, is it? All right, so it's not enough then for negligence purposes just to be the actual cause of the damage. Say that again. It's not enough for negligence purposes just to be the actual cause. In order for liability, in order for somebody to recover for the tort of negligence in a courtroom, you've got to have what we call proximate cause. Proximate cause means, was it foreseeable that the negligence would have resulted in the damage? Is my running the red light the proximate cause of Austin's car being wrecked? Yes, because it was foreseeable that running a red light would result in that. It's the proximate cause. It's the proximate cause of the damage to the pole. It's the proximate cause of the fire, although it's getting a little bit farther down the road. Is it the proximate cause of the dog dying? A lot less likely. So proximate cause means that the law draws a line somewhere down the consequences to divide up whether or not the actor is liable or not for the damage. Another way of saying that is, I'm liable for all the damage that my negligence causes up until I get to the line of proximate cause. Once we get beyond that line and it was not foreseeable, liability can't attach to me anymore. So when we say that causation is an essential element of negligence, we need proximate cause, not just actual cause. You've got some examples in there. A delivery driver negligently drops a lit cigarette in a warehouse parking lot. It starts a small fire, which travels through a vent system, sets off a hidden stockpile of explosives in a nearby factory. The explosion injures hundreds of people miles away. Somewhere along the line of consequences, proximate cause stops. And when proximate cause stops, liability stops. Where would y'all draw the proximate cause line in that scenario? After the fire? I don't disagree with that. It's foreseeable that if you throw a lit cigarette out the window, you might start a fire. It's foreseeable that that fire might do some damage local to where it started. It's not as foreseeable that, it's certainly not foreseeable that somebody's going to have hidden cache of explosives in their thing that you are inadvertently setting off. And it's not necessarily foreseeable that those explosives would injure somebody a couple hundred miles away. So we draw that line at proximate cause. There's some other examples in your, well, we can do them. We got time. Grocery store negligently leaves a puddle on the floor. Customer slips, hits their head, knocked unconscious. While waiting for help in the parking lot, the unconscious customer is struck by lightning. Was the store leaving the puddle on the floor the actual cause of the person getting struck by lightning? I mean, if we hadn't had this, if they had cleaned up the spill, the person wouldn't have slipped, wouldn't have gotten hurt, wouldn't have needed medical help, wouldn't have been waiting on an ambulance in the parking lot, wouldn't have gotten struck by lightning. But we're getting pretty far down the line past what's foreseeable, right? It's foreseeable that they might need medical help. Is it foreseeable that there's going to be lightning out in the parking lot that might hurt them? Let's change the facts and make it foreseeable. What might make it foreseeable that putting the customer outside to wait on the ambulance would be putting them in danger of being struck by lightning? There's a horrible lightning storm out there, right? So it's context specific. You guys at Chick-fil-A, what kind of negligence training do they give y'all? Do they call it that, or are you just thinking of all these things you have to do that now you're like, oh, that's to protect us against negligence? Yep. Say it again, Jace.
Like what signs, things like that, make sure other kids can be outside for lightning within 200 yards.
So that's something they train y'all on. Do you have to go and get them in if they're out there? If it's a playground?
If the teamers, like they can be outside taking orders. If it's
Oh, your employees. Okay, I was about to say. So if there's a lightning storm, you've got to pull the people that are standing outside inside. That's part of your duty of care to your employees, right? I mean, think about like all those cones that define where you're supposed to drive. I mean, you have a duty to set those up in a way that's easy enough for people to follow and understand. What about spills? What do they tell you about spills? Wait for it. You have to do it immediately. Yep. All that is protecting yourself against negligence lawsuits. Go down to Good Samaritan statutes. Well, I skipped over. Let me go back to the fourth element of negligence, which is damages. That's sort of self-explanatory. And in my example where I threw the laptop at Keyshawn, if he doesn't have any damages, then he can't bring a negligence suit against me. That's my defense, is you didn't suffer any damages. You might could prove that I had a duty of care. You might could prove that I breached it, but you can't prove any damages. There are things called Good Samaritan statutes, and those protect people who give emergency aid, not like the ER doctor. It's still the ER doctor's job. They're held to the standard of an ER doctor. But if I'm riding down the road and I see somebody in an accident, I stop. They're bleeding profusely. I try to stop the bleeding. I don't do it right, and they end up bleeding out and dying, and their family sues me for negligence. Good Samaritan statutes would give me a defense in that situation to say, I was helping out an emergency. I'm not a professional. You can't hold me to the standard of a professional. Somebody asked me in the 930 class, why does it say that in your outline, why does it say you usually cannot be sued if the outcome is negative? So the example I would give there is I'm driving down the road. I see a person who is in distress. I get out. It's a 95-year-old lady. She weighs 75 pounds. I think that she needs CPR. And so in order to make sure that I apply enough pressure to her, I get on her rib cage and I jump up and down to administer the CPR. That may be negligent, right? That's, if I don't do the CPR the right way with my hands or whatever, that's one thing. But if I'm doing something, if I'm attempting to give emergency aid in a way that's careless under the circumstances, the Good Samaritan statute might not protect me. But the main idea is that most of the time, if you're giving emergency aid, you're going to be protected from negligence. And that's, of course, to encourage us to help people.
So Good Samaritan is only for like, if it's just a regular person, but like if you do accidentally do like medical malpractice, then Good Samaritan.
Yeah, right. So like you can't go to the ER because your heart stopped and the ER doctor didn't diagnose it right. And you can't be like, well, it's just Good Samaritan helping you in an emergency. The ER doctor probably is held to a higher standard on the side of the road than I am too, because they're an expert. They're a professional.
Wait, what about being CPR certified? Somebody needs CPR, they don't do it right.
If you don't do it right, you're going to be held to the reasonable person standard, which is under the circumstances, you did the best you could. You're not going to be held, just because you're certified doesn't necessarily mean you have to be an expert in it. If you are certified though, and you do something colossally stupid, like the opposite of what you're supposed to do, then at trial I might say, well, Jason was trained in CPR. He was certified in it. So I know we have this Good Samaritan statute, but he knows better. I mean, we should hold him to a higher standard than someone who doesn't know CPR. That'd be my argument. If I was your lawyer, I'd be like, oh, no, man, you can't be going around imposing liability on people who are doing their best to help in emergencies. If he hadn't helped, nothing would have happened. So at least he tried. That'd be my argument as his lawyer. All right, defenses to negligence. What are some defenses? It's always going to be a defense to say that the plaintiff can't prove one of the four elements of negligence. All right, I did not have a duty of care in that situation. That'd be a defense I could use. Or even if I did have a duty of care, I didn't breach it. Yes, I have a duty to operate the correct way, and I did. My defense is that I did uphold the standard of care. You could use the defense that there's no causation. Yes, I had a duty to act carefully. I was careless. I breached that duty. But my carelessness didn't actually cause you any injury. Or it didn't cause whatever injury you do have. Damages. I could say, yes, I had a duty of care. I breached that duty of care by being careless. My breach was the cause of whatever, but you don't have anything I can compensate you for. I knocked you down when I opened the door. I've met the first three elements of negligence, but if you don't have any damages, my defense would be, I can't be liable for negligence. So failure to prove one of the elements is a defense. Assumption of risk is a defense. Okay, if I go skiing and I've never snow skied before, and I go to the top of the mountain and I decide to ski down a run that's marked experts only with 2 black diamonds, and then I get injured and I sue the ski people for negligence, they're going to say I assume the risk. I should know better than to go on a slope that's for experts when it's my first time. And if I did take that risk, that's on me. That's not negligent on their part. They don't necessarily have the duty to have an employee standing at the top of every run waiting to ask if somebody's an expert or a beginner. That's beyond their duty. Their duty would be to mark the runs correctly, right? Definitely, but not to necessarily make sure no one goes on the wrong one.
Is that kind of what the waiver is like?
Kind of well, if you sign a waiver, you are saying, I relieve you of any responsibility for negligence no matter what happens. When we sign those waivers, we are absolving the other person of any liability for negligence. And basically, we're signing away our right to sue them for negligence. But most of the time, they want you to sign those things to make it clear that you're assuming the risk. A lot of those things say, I know what the risk, they have told me there's a risk. I've been advised of the risk. I'm going to do it anyway. That helps when we go to court, because when we go to court and your defense is assumption of risk, if you've got something showing that I acknowledged it, I got no case. That's a lot better to have. So assumption of risk is a defense. Superseding cause is a defense. I gave you an example of that accidentally earlier when I ran the red light, hit the power pole, caused the fire, and the fire truck ran over the dog. Okay? I was the actual cause of that dog dying by running the red light, but there was a superseding cause that came in, which was the fire truck's negligence. In other words, it was really more their fault than my fault. That could be a defense to negligence. Contributory negligence and comparative negligence are related. And that allows a defendant to say, yes, maybe I was negligent, but so was the plaintiff. Let's say that I'm driving down University Avenue on the way to school. I am looking at my phone and texting. I'm not paying any attention to where I'm going. And I run over Garrett. Garrett was napping in the middle of the road. Okay? He sues me for negligence, saying you were negligent in distracted driving. You weren't paying attention to where you were going. You had a duty to pay attention. You breached that duty. Your breach caused my injuries, and I've got all these damages. He can meet the 4 elements of negligence on me. But at trial, I could use the defense of, yeah, but you were negligent too, because you've got a duty not to go around sleeping in dangerous places like the middle of the road. So your negligence came into play as well. Courts will treat that in one of 2 ways. One way is that some states will say, if the plaintiff was at fault at all, even a little bit, then the defendant is off the hook. 99% my fault, 1% Garrett's fault. If we're in a state that recognizes contributory negligence, I'm off the hook. Contributory negligence means if the plaintiff is at all at fault, they cannot recover for negligence from the defendant. That sounds pretty harsh, and it can be harsh. So most states have adopted something called comparative negligence. And in comparative negligence states, the judge or the jury is allowed to hear all the facts and decide the percentage of fault that each party should be responsible for. So when I ran over Garrett, our jury might decide, well, Tebow was 50% at fault for this, but Garrett was 50% at fault for this. So we're going to let Garrett recover for his damages, but we're going to cut his award by the percentage of fault that he has. In this case, we're going to cut it in half. He was 50% at fault. He loses 50% of the award. Okay? Austin sues me for negligence, and the jury awards him $1 million, but they determined that he was 10% at fault, and I was 90% at fault, then they're going to reduce his $1 million award by 10%. And he'll get $900,000 instead of $1 million. That's comparative negligence. A lot more fair than contributory negligence. All right, the last thing I need you to know for today is I want you to set negligence aside for a second. There is something in the law called strict liability, and some torts don't require intent, and they don't require carelessness. Some torts just require causation. That's called strict liability, meaning you're going to be liable for the damage you did no matter how careful you were, no matter whether you had a duty or not. You did this, they were harmed by it, we're not getting into fault, you're responsible. It's not common. It's for things that involve typically like very dangerous activities, like using dynamite. Okay, if I'm going to use dynamite out here on the construction site to blow up something, if I'm blowing up that courthouse downtown when they finally build a new one, okay, I could be as careful as possible, but I still might harm something by setting off the dynamite and that building caving in. If a tort only requires strict liability, then I'm going to be liable no matter how careful I was. Abnormally dangerous activities. If I own a tiger, a wild tiger, and I have the best tiger cage anybody's ever had, I'm as careful as anybody could ever be, but a hurricane comes through and rips off the roof of my tiger cage and he jumps out and kills somebody's cat. Okay, I was careful. I wasn't negligent. I sure didn't intentionally cause harm to somebody's property. But under the theory of strict liability, I might be held liable no matter what. Abnormally dangerous activities sometimes don't care about negligence and they don't care about intent. So, on Tuesday, let me back up. You are going to have a quiz. You have 3 Easter eggs. One is in the lecture outline for Tuesday. One is in the key terms. And then one today is from this lecture, which is that our animal this week is a pig. A pig. Everybody got that? You got pig, plus you got a color in the outline, and you got a fruit in the key terms, I think. 3 Easter eggs for this week. The quiz on Monday is only going to be about what's in your outline and what I've talked about this week. We're going to do some cases and some discussion and all that next week, and we'll worry about that next week. You're only responsible for what's in the lecture outline and stuff we've talked about in class. That'll be due Monday night. I will see y'all next week. I think we already handled, if you came in late, let me know. If you went to the career fair and I didn't give you credit yet, let me know. See y'all. Have a great weekend. All right, we'll see you Tuesday.